Andrew and Elizabeth, thanks so much for coming into my office today. As you know, we've been working with each other over the last few months to discuss your current financial situation and your goals, and we wanted to talk about some ideas as far as how to get you on a path to reach those goals. I wanted to speak with you specifically today about your estate planning needs, and the first thing I'd like to do is review what I think I've heard from you to make sure I understand your current situation. The first thing is that both of you have indicated that you've never signed a will or a trust document, so we don't have anything in place as far as that goes at the present time. The second is that you said that you'd like to leave your assets equally to your two children, Madison and Ethan, including any life insurance proceeds as a result of your death. You also indicated that wherever possible you would like to avoid having your assets pass through the probate process. So one of the things that we'll do today is discuss your assets and their current titling and see which ones would fall into probate and how we might want to retitle them to avoid that. Lastly, I know that you both indicated that in the case of a terminal illness, neither of you wanted to have extraordinary medical intervention to prevent your death. So the first thing I wanted to talk to you about as far as my recommendations is I'd like you to meet with an attorney and have wills drafted. There's several purposes of a will. One of the first things that it would accomplish would be to name your executor. And the executor would be the person who would be responsible for settling out your estate, making sure that the assets that you have at death would pass to the proper parties, and also making sure that they've complied with all the state requirements as far as settling an estate, taking care of any federal filings if in fact they're needed, and so on. You would probably want to name each other as your executor, but you'd probably want to name a backup as well, just in case your spouse predeceases you and you haven't updated your will, or perhaps your spouse is still alive but not in a position to handle those affairs. The second purpose of your will would be to name a guardian for your daughter Madison. Now, if something happened to you, Ethan is already living with his mother, so Ethan would not need to have a guardian appointed. However, if something happened to the two of you, of course, you'd need to think about who you think would be in the best position to raise Madison in the way that you envision. Someone who has similar values, and you would also probably want to discuss that with them to make sure that they would be willing to take care of that for you, to welcome her into the family and so on. Thirdly, I recommend that you, through your will, authorize the creation of a trust at your death. And the purpose of the trust would be to hold any assets that you leave behind to your two children. And you would appoint a trustee. This would be a person who would be responsible for managing the assets on behalf of the children and also making disbursements to them as authorized through your trust document. You would think about how you would want that to happen and when you would want that to occur. The person that you would want to serve in that role would typically be someone who has some degree of financial sophistication, so they would be able to make decisions as far as what types of assets might be appropriate, or they could even hire someone to do that role, but you would want someone who you think would have good judgment in hiring a third party to manage the assets. And of course, most importantly, you want someone that you would consider to be trustworthy and in fact would manage the assets on behalf of the children and not use them for their personal gain and so on. Another thing that I'd like to talk to you about concerns your wishes to not have medical intervention in the event of a terminal illness where death is imminent. And what I'd like you to do there is when you meet with the estate attorney, talk to them about advance directives, which are also known as a living will. This would be a document in which you would communicate directly with the physician that would be giving you end-of-life treatment to let them know what kind of intervention you would want or not want, and so on. Another document that I recommend you both execute that is associated with medical care would be a power of attorney for health care, also known as a healthcare proxy. And the purpose of that would be, let's say you're in a car accident and decisions need to be made as far as what kind of medical treatment would be best. If the medical staff needs to consult with a family member, if you have this document specifically naming a party, probably name each other, of course, then they know who to turn to in case there's any kind of dissension between the family as far as what should be done. So the power of attorney for health care is different than an advance directive. In the advance directive, you give your direction directly to the healthcare staff, whereas with the power of attorney, you're actually giving authority to a third party, your spouse, to make those decisions on your behalf. All right, and the last thing I wanted to go over is you had specifically mentioned that you didn't want your assets to go through probate. So I took a look at the statement of financial position, and you had reported that you each have a retirement account. Andrew, you have a 401k account, and you indicated that Elizabeth is a beneficiary, so that asset won't go through probate. And Elizabeth, you have an IRA, and you indicated that Andrew is a beneficiary. Again, that means that we don't need to have this asset go through probate. And what that means, of course, is that we're saying that if you die, we don't need to look to your will to see where the money in the 401k or the IRA will go. Okay, we already know that because of the beneficiary instructions that have been executed by each of you. I wanted to talk a little bit about your checking and your savings account. Andrew, you have a checking account in your name only. Elizabeth, you have a savings account in your name only. You have two choices if you want to avoid probate. One of the things that you could do is just retitle that asset to be Andrew on the checking account. It could be Andrew payable on death to Elizabeth. It would still be your checking account, Andrew, but upon death we'd have instructions that it would be transferred over to Elizabeth. Elizabeth, you could do the same thing with your savings account. The alternative for both the checking and savings account is that you could just choose to retitle them as joint tenants with rights to survivorship titling, and that way they'd be jointly owned while you're alive, and they would pass to the surviving spouse upon either of your deaths. I also would like to talk about the GFD stock. Andrew, you inherited this from your grandfather. At the current time, it's solely in your name at a brokerage account. You could title it as still in your name with transfer on death instructions to transfer over to Elizabeth. So it would be still a singly owned account while you're alive, but transfer to her upon your death. Or you could retitle it as being a joint tenants with rights of survivorship type of account, and that way it would be jointly owned while you're alive, and it would just pass to the surviving partner upon either of your deaths. And you wouldn't have to worry about any gift tax consequences there, because married couples can pass an unlimited amount of assets to each other without it being considered a taxable gift, because you're both U.S. citizens. So those are my recommendations. I'd like you to consult with an attorney. I'll be happy to answer any questions you may have, and then I suggest that we meet again in a month so we can follow up and discuss what the next step is with your financial plan. Thanks again.